So the hero's journey has filed a motion to compel arbitration. They're claiming that Daybreak's own EverQuest end user license agreement, EULA, forces disputes in arbitration. And because Daybreak chose to sue the defendants personally, and they are admitting that they clicked agree, that they should also be bound by that contract. So at first glance, when I saw this, I was like, man, that's genius, because the whole case has been, Daybreak saying we're personally suing you. THJ says, no, you got the wrong people. You should be suing EverQuest LLC. They operate and manage the server. Now THJ is saying, now that you're going to sue us and not the LLC, we are bound by the EULA because we are users of EverQuest and clicked agreement. And as most people know, EULAs are considered binding contracts that requires the user to click agree, which the defendants are now admitting to. And Daybreak had already claimed that they did. So as usual, you dig a little bit deeper. But first, arbitration happens behind closed doors. So there's not going to be any public fights, filings, like none of the awesome stuff that I guess we're covering that we're probably sick of at this point. Arbitrators can award damages. And what this does for removing it from federal court is that we're not going to see an injunction. In the long run, does it increase the chances of THJ winning the case? Absolutely not. By no means. The arbitrator is going to have a little bit more leniency, doesn't have to necessarily follow precedent and kind of piece things together, but the law is the law. And I still think THJ's case is relatively weak. However, it does get rid of the injunction and it does give them more time to settle. There's been a lot of precedent on how courts treat arbitration clauses inside EULAs. The biggest one is AT&T Mobility versus Conception, which is Supreme Court 2011. It basically states arbitration provisions are enforceable even if the language is broad. And then Epic Systems versus Lewis in 2018, it reinforced arbitration agreements and standard contracts must be honored. Like I said, it's a private contract between an individual and the company, even when there are statutory rights at issue. Our arbitration is valid unless Congress explicitly said otherwise, and has not done that for infringement or DMCA. And then there was, of course, the Maple Story emulator, which is more recent, 2023, where the court enforced arbitration clause in the EULA against the defendants, where they were accused of copyright infringement and their unauthorized servers. So the courts have over and over again accepted EULA as a binding contract, and they are willing to send IP disputes in arbitration if the contract language is broad. That's the key word here. And I have no idea what the EULA for EverQuest says. The defendants basically admitted that they as individuals had clicked accept on the EULA by submitting their exhibits, the ones from 2018 and 2022. So we take a look at one of them. The other one has similar language too. So basically the arbitration is 12.3 in this one. It says, if you and Daybreak are unable to resolve any dispute through negotiation, or if either you or Daybreak refuses to comply with the provisions of any written negotiations of settlement, then except for any excluded disputes as hereinafter defined, such disputes will be resolved through final and binding arbitration before a neutral arbitrator. So they're mentioning except for any excluded disputes. Then if we scroll down further, as used in this agreement, excluded dispute collectively means A, any dispute relating to the infringement, misappropriation, and or other misuse of intellectual property rights other than patent rights, including, without limitation, claims seeking injunctive relief. And then there's B and C, but you can already see that Daybreak had already thought about this, and that now that the defendants have admitted that they clicked 2018, and they're similar in both of these, there is a similar carve out in the arbitration clause that excludes disputes, which is now a binding agreement that they have admitted that they signed, collectively means any dispute relating to infringement, misappropriation, and any other misuse intellectual property rights other than patent rights, including without limitation, claims seeking injunctive relief. So at first I thought like, yeah, this is awesome. We're gonna play THJ a lot longer. They're gonna work something out, come to some type of agreement. But right in the EULA that they just admitted that they signed as personal users, it basically says like, hey, not covered in this EULA are infringements, are copyright infringements, etc. The judge should just look at this and be like, yeah, no, like that's how it should go. Obviously, who knows what they'll see in here, but their EULA is very specific. And now that the other parties, the defendants, have admitted it is a binding contract that they did indeed sign through their attorneys, this should be enforceable. And in here, it does exclude copyright infringement. So I think what happened, and the thing I was really thinking would happen if this wasn't in here, is that Daybreak's response would be to put an amendment in to add an EverQuest LLC to the lawsuit, because an LLC can't click accept and agree to play EverQuest. An LLC doesn't play EverQuest, so they're not typically bound to an EULA and user license agreement. So that would have brought the lawsuit back into play and bought more time for THJ, I guess. I feel like they did it because they were due to respond today, so they threw this together. You guys can make the call. I mean, it's right in the EULA that they now have agreed that they did sign, and there's plenty of precedent making this a binding contract. And so that's what we're looking at here. So while I was like, damn, that was like a solid move, after further investigation, I'm thinking not. I'm thinking that they probably put it because they were due for a response and had to come up with something. I don't know what they're going for by saying you got the wrong people. It's actually the LLC you should be suing. And Daybreak says, no, it's not, blah, blah, blah. Then they come back and say, well, since you're suing us personally, we did assign this agreement. Here's what it says. So you're bound to arbitration. And inside the same exhibit they submitted, there's an exclusion for what type of things can go through arbitration. I don't actually know where they're going with that, or if there's some further strategy or some other chess move they're waiting to play on from that. But that doesn't seem like a good move to me. So we'll see how this goes. Go ahead and leave a comment which way you think this will roll, and I'll keep updating you.